So welcome to CCNG September Town Hall. We're happy to see you all here. Thank you to those of you coming from the board meeting that you also were able to make it to this. Today, we're going to have two guests, Kirby and Eric, who I will let introduce themselves more thoroughly, but just to give an introduction, who will be talking about the Telephone Consumer Protection Act. So, Kirby, if you want to take it away.
Sure. Thanks, Jill. So Kirby McLennan. My firm is Contact Center 411. We're a pure contact center consulting firm, and we focus on all things, everything related to contact centers, from operational improvement to technology, outsourcing, pretty much just everything A to Z. And I'm not going to turn it over to Eric just yet, but let me go ahead and do a little bit of an introduction, and then he can add to that whenever he kicks off his portion. But very pleased to have Eric manage to join us and squeeze us into his busy schedule. Eric is a very prominent attorney in the TCPA world, and if you're not familiar with the Telephone Consumer Protection Act, that's in one degree, that's a good thing. On the other hand, if you're not, it's probably good that you're dialed in here today to learn a little bit about it. But Eric has built a firm very innovative and focusing on TCPA litigation, how to avoid it, how to coach his clients. He does a ton of seminars and events to help educate the industry. And in fact, he just got home. He's been off on a on-site event for the last 2.5 days. And so he's scrambling to get back into town and join us this morning. But at any rate, he has a tremendous amount of resources and knowledge around everything about staying compliant with TCPA, and that's what we're wanting to focus on today. And it's going to be pretty high level because some of these topics you can really get down in the weeds, and it takes much longer than we have today to talk about. So to start with, before I turn over to Eric, maybe we've got a couple, I think 4 survey questions for you guys. And we recognize that the majority of this group is probably mostly focused on inbound, but there's certainly things that you need to be aware of, even on the inbound side of your operations. And certainly folks that are involved with outbound programs, you're going to be more aware of this, and you may be very valuable and helpful to us today to throw out a few questions or comments about some of your experiences.
So we have 4 questions. We're going to leave them each up for about 45 seconds. Before the next one goes up, we'll take a few seconds to look at it so Eric and Kirby can get that information, and then we'll get the next one going. So I can see how many people answer, and I'm watching you. Make sure to get your full votes in.
Hey, Eric, while they're doing that, I got a question for you. Just the way my mind works. Which side of the table do you sit on? Do you go after people that are not in compliance, or do you help people to get in compliance? I just want to know, are you, hero or villain?
I'm the good. In fact, I'm the guy in the history of call centers, man. I created Reach. I defend you folks in front of the commission, in front of the FTC, and of course in federal court class litigation, where I've defended more of these than any human being alive. So I'm super duper good guy.
Good. Because I think people were a little panicky that, like, wait, we have an attorney on? Oh my God, we're in trouble already.
Good kind of it. The good kind.
Yeah, so no, thanks for asking that, David. I should have pointed that out.
From this first poll question, it looks like most people answered outbound and inbound.
Okay.
In terms of describing their customer interactions. So let's keep that in our mind and go to the next one, which here is what best describes the type of outbound interactions conducted at your operation. All right, I'm gonna pull this one down and share it. So here, more people answered ongoing dedicated outbound campaigns, but there is a decent number who also said outbound only as necessary.
Okay, that last one I was very interested to see response to that one, because as I mentioned earlier, there's definitely implications for all the operators that are primarily inbound, because you do have to follow up with people and initiate phone calls, text messages, what have you. And sometimes, well, there's always technology involved, but sometimes callbacks can get put into a scheduling system, and that opens up a whole new can of worms potentially for what you have to follow and look out for, just because you're in that realm of an automated dialing system. So
question 3, do you purchase leads from an industry provider?
And the reason we put this one in here is, you know, there's been a lot of companies in the industry, a lot of places you can go and you can buy leads, and for a couple of things, now with the new 1-to-1 consent ruling that is coming out, you have to be very careful about where those leads come from and what exactly a potential customer consented in terms of being contacted. And so it's a potential minefield there.
So we have some pretty interesting results here with the large majority of people who answering never.
Yeah. Okay.
And then the last question, what best describes TCPA compliance at your operation? All right, so these results are also up with, again, the majority we have a policy and a defined process in place, and then some people coordinate with in-house legal counsel.
Yeah, external. Okay. Okay. Yeah, good. Just right off the bat, I'm gonna say a good question there from Catherine on you know, how many channels affected by this, so that as we get a chance to touch on technology, well, that's a very good question. So again, I'm going to let Eric speak as to, you know, his experience in his firm a little bit more, if he'd like to, before we jump into the topics. And thanks, David, for asking that question. You know, he and his firm and all of his attorneys are definitely the good guys in this. And in addition to that, they have created an association, a group called REACH, which again, I'll let him talk about, but it's designed to go out and be proactive with the governing agencies to say, hey, we know there's bad actors out there, but we're trying to be the good guys, and we want to weed them out as well, so that we don't all suffer from the bad actors. So anyway, without anything further, let me turn it over to Eric, and then Jill, if you would go ahead and roll it to the next slide, please.
Hey folks, well, nice to meet all of you. Thanks for having me. Really, really cool to be hanging out with such a knowledgeable group of contact center folks. So I'm Eric Troutman. I'm better known as the czar of the TCPA. I run tcpaworld.com, where we break down every case every day. But kind of probably more importantly, I've been a litigator that has done nothing but TCPA, class litigation, and regulatory compliance and advocacy to the commission and to Congress for 15 years now. As I alluded to earlier, no human being alive has defended more of these cases than I have, which is kind of a big brag, but also kind of true. But obviously today I'm just going to talk to you about the law at a high level. I love it that questions are being asked. Shout them out, man, or put them in the chat. You know, we don't have a really defined program today. I'm just going to give you a high level review about the TCPA, things you should keep in mind, and some of the changes that are happening right now. But to answer that first question, does it only apply to voice or other channels? The TCPA applies to all channels. All communication efforts through an outbound channel to a cell phone are going to be covered, and pre-recorded technology that's used to contact a voicemail service, including a landline voicemail, is also going to be covered. So let's kind of talk about the statute at a high level. All right, first, very important that you understand the TCPA is the biggest cash cow in litigation history. More multi-millionaire plaintiffs' lawyers have been made under this statute than under any other federal statute. There are hungrier, more sophisticated, better paid attorneys in this area than in any other area of law. And the litigation that they bring is almost always class litigation, complex litigation in federal court, which is the highest level of litigation and the highest level of court that we have in this country. So these cases are just deadly serious. And that's not surprising because the penalties for violating the TCPA are $500 per call. And again, these are class cases. That means that every call you make over a 4-year period is going to be at issue in a single case. Now, you can imagine how many calls, those of you that are doing outbound campaigns, how many calls you're making in a given year, in a given week, in a given day. Multiply that times 500, and then recognize that the exposure here could be 4 years of every such call that you've made. So most of the cases that we defend here at Troutman Amin are multi-billion-dollar cases. Virtually all of our cases are bet the company cases, which is why folks come to us, because we are the most knowledgeable and experienced attorneys in the world in this. And again, when you're dealing with the plaintiff's bar, who is just as sophisticated, just as powerful, and incredibly well-funded, you really do need to have some juggernauts fighting on your behalf. You can't just go down to your local law firm and work with your buddy that you know down there. So it's a very, very aggressively litigated statute. It is incredibly high stakes. One thing I should also mention that everyone should keep in mind is that there's personal liability when the TCPA is violated. So that means even if you work for a company, even if you're just an employee, even if you're just doing something that your boss told you to do, running a campaign, because that's kind of your job, understand that your personal identity may be disclosed in discovery, and you may be separately and personally sued in that case or in a separate case for your personal bank accounts and your house and your car. It's a terrible statute. It's terrible. And you really do need to pay very, very close attention to this thing. So there are two different restrictions as we start talking about the TCPA and actually what it does. Recognizing that this is the crown jewel federal response to the robocall epidemic, right? This is the statute, the law that is supposed to prevent robocalls. It is the law that is supposed to guide call center operations in terms of how you're doing outreach. And so it really is something that courts love to enforce. The FCC and the FTC love to enforce. And as I already mentioned, this slew of thousands of litigants and litigators out there who are, the extreme ambulance chasers. But unlike regular ambulance chasers, these guys are not lazy. They're sharp, they're intelligent, and they're very, very aggressive. But there are two restrictions under the TCPA, and really just two that you need to be worried about. They're separate and they're different, so you have to keep them in mind. First, thou shalt not use regulated technology to make outbound calls without the right level of consent. Okay, we're gonna have to unpackage some of that here in a second, but that's the reg. Cannot use regulated technology to make outbound calls without the right level of consent. That's one. The other is you cannot make marketing solicitations to numbers on the DNC without the proper level of consent. Okay, two separate provisions. That's all there really is to the TCPA. And if you can just kind of master those two provisions, you can stay out of a ton of trouble, frankly. Now, even though there's only two provisions, as you heard me say those words, you probably thought to yourself, well, what does that mean? Well, what does that mean? What does that mean? These words are all vague, and these words can actually be very difficult to apply in a factual setting, which is why we're going to spend a little time kind of unpackaging some of this. I want to start with the DNC rules, actually, because they're a little bit easier, frankly, and hopefully most of you already have a DNC policy. If any of you are doing outbound calls for marketing purposes, if you're making outbound calls for marketing purposes, you must have an internal DNC policy that is in writing and trained on at least once a year. Now, I saw your responses to the poll. It looks like at least 2/3 of you and maybe more are doing this. So that's great. But if any of you do not have a written DNC policy that you are training on once a year, and you're doing telemarketing outbound calls, even occasionally, you are in harm's way. Okay, you're already violating the law. You don't want to be there. Assuming you've got that policy, of course, that requires you to honor any inbound, any do not call requests that you might be receiving from a customer, put them on that list, keep them there for 5 years. But that's just the internal DNC rule. Additionally, in order to make an outbound solicitation call to a number on the DNC, you have to have either prior express invitation or permission, which has to be in writing, or you must have a established business relationship, or there must have been an inquiry. Now, I don't know enough about your individual operations to know whether, for instance, you are a brand that is making outbound calls on its own behalf, or if you are a marketing or third-party call center that is making calls on behalf of somebody else. If you're making calls on behalf of somebody else, then you can rely on the established business relationship or the inquiry that belongs to the brand. And of course, if you're making calls on your own behalf, you can rely on the established business relationship or inquiry for yourself. The established business relationship is 18 months after the last transaction, including a payment on a revolving credit line. Hopefully, this is all making sense to you folks. And feel free to stop me, pause me at any point. So that's the basic high-level rules around the DNC rules. You have to have that policy, you have to honor do not call requests, and you have to have the right level of consent before you make an outbound call to a number on the DNC, or you have to have the inquiry of the established business relationship. You can, in this country, still engage in cold calling, marketing, as well as non-marketing, so long as you are not contacting numbers on the DNC. And that includes B2B. All right. So many times people say, oh, B2B, TCPA doesn't cover B2B. Oh, yes, it does. Oh, yes, it does. Both under the regulated technology provisions and the DNC provisions, even B2B calls can be covered where the number that is called is a mixed use call, meaning the number is used both for, I think I misspoke there, where the number called is mixed use, meaning if that number, like my phone, is used as my business phone, but I also use it as my personal phone, then it is still a residential line for purposes of the DNC. And the fact that you're calling me for a B2B call doesn't matter. I can still sue you for a DNC violation. All right, so that's DNC. One other thing to keep in mind is under the DNC rules, if you have a valid policy, again, that you're training on, and you scrub the DNC regularly, then you can take advantage of what's called a bona fide error defense, and you can have a complete defense to a DNC claim if you accidentally get sued because you violated the policy by accident. All right. That defense does not exist in the other world that we're going to talk about right now, which is the regulated technology world. And most of you that are working in a call center are going to have access to regulated technology. So you're going to want to listen up here. Regulated technology includes any form of an auto dialer, which we're going to talk about here in a second, as well as a pre-recorded, artificial, or AI created voice message. So if you are using any kind of a press one campaign, outbound IVR, any form of generative outbound AI, you are using a pre-recorded or artificial voice. That means you're regulated technology. Yes.
What if I start out with just nothing but a pre-recorded announcement? For instance, this call may be recorded.
Yes, that is sufficient to trigger the statute. If the first words or sounds that the consumer hears are a pre-recorded artificial or AI-generated voice, that is now a regulated technology call that requires the proper level of consent under the TCPA. All right. Now, that I think is easy enough to understand. What is more complicated is when you're looking at whether or not you're using an auto dialer. And I don't want to spend too much time on this. Plus, I don't have like a bunch of slides kind of really breaking it down. So you're not going to be able to conceptualize it very well, I don't think. Usually I've got like 6 really kind of nicely worded slides here. But at a high level, just understand that whether or not you're using an auto dialer does not turn on whether or not a human being is doing something in connection with the call. Most people think, hey, I'm manually placing the call, therefore I'm not using an auto dialer. I'm clicking to call, therefore I'm not using an auto dialer. While that makes intuitive sense, that is not the law. The definition of what's actually called an automatic telephone dialing system does not look at whether or not a human being is used in any way, shape, or form to place the call, which is ironic because, of course, you would think if I'm doing something, then it's not automated, it's manual. But that's not the way the law is written. Instead, whether or not a call is made manually or using automated system looks at the functionality, the capability of the system that is used to place the call, not at how the call is placed. So many of you might be using a system that's got a predictive mode, preview mode, maybe a power mode, and you might think, hey, look, I'm using preview mode, so therefore this is a click to dial, this is a manual call. But the answer to that is absolutely not. If that is an integrated software solution, even if it's cloud-based, you might still very well be using an auto dialer. And the court has found, for instance, 5.9 qualifies as an auto dialer, at least might qualify as an auto dialer. The answer as to whether or not something is an auto dialer, again, it turns on the source code. It turns on actually the latent capabilities in the code of the system. And in order to be safe, meaning to feel like you're not using regulated technology, you really actually have to understand your source code and whether or not there's random or sequential number generators in the source code, even if they're never used as part of your campaign. All right, so just keep that in mind. Why do I kind of lay this out? I lay this out because if you're using any form of a out-of-the-box third-party dialing solution or suite of solutions, there is at least a moderate to high risk that that is an auto dialer. So you have to keep in mind that these systems require the proper level of consent to make any outbound calls. But that includes those of you that are doing follow-up calls. Doesn't matter. If you're following up with a consumer for a marketing purpose, you still are going to have the proper level of consent to make this outbound call using regulated technology. Now that we understand what regulated technology is, let's talk about the two different levels of consent that are applicable here. One level of consent is when you're making marketing calls. That is going to be what's called prior express written consent. And those rules are about to change. And you see right here, we've got this one-to-one consent ruling. We're going to talk about that. Although, really, since only like a few of you are buying leads ever, I'm not sure how impactful it's going to be, but we're going to talk about it here in a second. The other level of consent is for informational or transactional calls, and that's not written. However, you still do need to have what's called express consent. Now, mercifully, the FCC, which is the federal government regulator that implements the TCPA, has held that anytime a consumer provides the phone number directly to the caller for the purpose that is closely related to the call, that consent has been given. In other words, if you're calling for informational, non-marketing purposes, let's say debt collection, and the consumer provided their phone number on the credit application, and now you are a call center working for either the creditor or a debt collector, and you're making an outbound call to that phone number that was provided by the consumer in connection with that account, you can use both auto dialers and pre-recorded voice messages to contact that consumer, at least until the consent is revoked. So that's a good rule. I will note that there is some flux now following the Loper-Bright Supreme Court decision in terms of whether or not that FCC determination is still binding on the courts. There's like a little asterisk. There's a different act called the Hobbs Act, which gives the FCC and the Atomic Energy Commission incredibly strong powers to pass laws and regulations that are given deference beyond Chevron deference. So even once Chevron deference went out the window, this other act called the Hobbs Act still imbues the FCC's rulings with incredible power under the TCPA. However, certain procedural safeguards have to be followed before the Hobbs Act applies. It is unclear whether or not those were followed in connection with the 2009 ruling that I'm talking about. So I'm just asterisking this, little footnotes on this. Obviously, let me pause and say, none of this is legal advice. You know that. But as you can tell, there's some complexity here. So you might want to consult with an attorney, if you haven't already, to make sure that your processes are where they need to be. All right. So
Larry,
go ahead.
Just interject real quick. So obviously, he's covering a lot of information, fairly quickly because, we have a short amount of time here. Want to make sure we get questions. So someone was asking about, is there an explicit definition of what a marketing call is?
There is an explicit definition. It's found in the CFR, which I know you guys read all the time, 47 CFR 64-1200. You're reading this constantly, I assume. A marketing call is any outbound call for the purpose of encouraging the purchase or rental or investment in any good or service. All right, so if you're making any call for the purpose of encouraging anyone to invest in, rent, or buy anything, good or service, that is a marketing call. Okay?
How does that relate to healthcare?
So healthcare does have a special exemption, secondary exemption. But generally speaking, healthcare is a good or a service. So any outbound call in connection with the effort to sell healthcare, including insurance, is going to be a marketing call. Now, there is a separate exemption where if you are making an emergency contact for healthcare purposes, you do not have to have consent. And if you're making a treatment contact, even if it's not for emergency purposes, then you can make that outbound call with regular express consent, not express written consent, even if that treatment call might otherwise have qualified as a marketing call. Now, for everybody else that's not in healthcare, you don't have that exception. So for instance, if you are with a mortgage company and you want to notify everyone, hey, the Fed just dropped the rates are coming down, you should, you just say you stop there, right? Rates are dropping. Obviously, that might feel to you like, hey, it's just informational. I didn't say anything marketing. I didn't say come in and get a refinance, even though obviously that's what I was implying they should do. The fact that call is what people or what courts consider a dual purpose call will still have it treated as a marketing call, meaning you sent it informationally, but the purpose was ultimately to get that consumer to come and buy, in this case, a refinance product from the lender. Okay. So there's your line. I know it's not as bright as you'd like it to be. I could give you some really extraordinary examples where a court found something that seemingly was very informational was still marketing. The courts love to expand this statute again because everyone hates robocalls, and the courts, I think, mistakenly assume that every robocall, every automated call is somehow disdainful to consumers. And for those reasons, they really are very aggressive in expanding the statute to apply to things that they really ought not apply to. But once you make the determination as to whether or not you have a marketing call or a non-marketing call, right, that is, of course, where the split of consent comes. Again, marketing, you must have express written consent. Non-marketing, very lenient standard for express consent. Really, you just have to make sure the number is the correct number and that it came from the consumer. There are
Eric?
still... Yes.
I'm sorry. Maybe this is the wrong time to insert, but it's on my mind. How does all this, if at all, apply to text messages?
It all applies to text messages. I think that was one of the first things I said out of the gate. If I didn't, I apologize. This applies to any out of any kind, a cell phone of any period.
Okay. So to be clear, my cellular provider isn't calling me, but they're sending me a message that could be tied to bundling up and buying more from them. That's a marketing call.
Stumbling into interesting standalone exemptions. Actually, your wireless carrier is the only entity that is permitted to make outreach to its members. I don't know why this exemption exists, but your wireless carrier is allowed to send you text messages without consent, even to offer you a good or service. Nobody else is allowed to do that, but your wireless carrier can.
So I picked the wrong example, but my, okay, fill in the blank, my bank.
Yes.
Okay. So that text message is considered a marketing call.
That is correct. Now,
okay, thank you.
Rules apply though, right? A manually sent text message would not trigger the regulated technology provisions, but it would trigger the DNC provisions. So you'd have to know whether or not that text message was sent using that automated system, which, as I already told you, is very difficult to discern. It's not easy to know. You really have to look at the code. All right. So let's see, where were we? We were talking about consent, and then once you've got the correct level of consent, understand, I was talking about even in the informational setting, even though express consent is relatively easy to obtain there is still some risks, and hopefully you guys all know about the phenomenon of wrong number calling. Understand that even if you get the customer's consent, hey, I'm Bob, I'd like to receive a call, but let's say Bob gives you a wrong number. Guess what? If you're using automated technology to contact a cell phone, you do not have the called party's consent, because you have to actually have the person who owns the phone has to have given you that consent. And Bob, in this instance, gave you the wrong number. So guess what? Even though you did nothing wrong and Bob screwed you over, you are liable for making an illegal call. There's strict liability here. And there's a couple of things that you can do to protect yourself. I'm not sure I can give you kind of all the parameters here in the short of time that we have, but you want to be very cautious in terms of how you're coding data around wrong numbers. The plaintiff's bar loves to use your data against you. There are solutions out there, vendor solutions, that will help you to detect whether or not a wrong number might have been provided to you. But most importantly, those of you who are calling on aged data, it doesn't sound like you guys are calling on leads very often, but maybe you're servicing loan portfolios, let's say. If you have not had a contact, an RPC, a right party contact with that consumer on that number for 60 days, 90 days or longer, Again, not legal advice, but you should really think about using what's called the reassigned numbers database. This is a database that is provided by the FCC that allows you to check those phone numbers to see if they're still valid or if they've been switched to somebody else in the 60 to 90 or 120 or however long it's been since you talked to that customer. The reason is, again, if you make a wrong number phone call, you are liable for that, period, full stop. It doesn't matter that you tried to call the person with consent, irrelevant. What matters is, did you call a cell phone and that call, the cell phone owner, that subscriber, are they the ones that gave you the consent, yes or no? So definitely think about using that reassigned numbers database. That's very helpful. All right, so let's finally get to the second little bullet here, which is the 1-to-1 consent ruling. Again, most of you folks do not buy leads, it sounds like. Currently, believe it or not, the lead generation industry is this mill of websites, largely comparison shopping websites, that generates consents from consumers to let other people call. So if you are, I'll pick on my client, Loan Depot. I love Loan Depot. They're a big client of mine. If you're a Loan Depot and you want to contact people to ask them to have a mortgage, you're not just going to cold call people. That would be dumb. Instead, you're going to work with a company, let's say Lending Tree, right? That is a lead generator. And they work by allowing people to come to their website and shop for different rates, right? Loan Depot puts their rate up on Lending Tree. The consumer wants to hear from Loan Depot. They click the button and they send the lead over to Loan Depot. Loan Depot now has potentially a qualified customer that Loan Depot wants to reach out to. What's the problem with that? Nothing. It's great. But not every website operates that way. And there are many companies that are not, websites that are not as nice and good as Lending Tree that essentially say, you know, click here for a free quote, or click here for a free offer, or click here in some cases to get registered to win a $500 gift card to Walmart, whatever it is. And in the fine print, these folks are agreeing to receive contact for telemarketing purposes from thousands of companies. The FCC hates this, and for good reason. I hated it too, which is why I created the industry group called Responsible Enterprises Against Consumer Harassment. That's REACH, which was the first industry group to set standards for the industry to tell them to knock it off. Stop tricking consumers, stop selling their data 5,000 times, stop telling lead buyers that you're getting a qualified consumer when the consumer was tricked into filling out the form. And now Loan Depot in that instance would be calling somebody who doesn't want to hear from them. And guess what? Getting themselves sued under the TCPA, which is terrible. These lead generators were basically just taking everybody for a ride and getting away with it until REACH came along. The FCC, following REACH's lead, has issued its own ruling that's going to be effective in January of 2025 that says essentially you have to cut all of that out, guys, right? If you are running a website that's gathering consent, you have to give the consumer the specific name of the entity that is selling the good or service that either will be calling directly or calling through a third party. So for instance, again, going back to the Lending Tree example, it wouldn't be enough for Lending Tree to say, click here to get a quote from a qualified lender. They'd have to say, click here to get a quote from one of the following lenders. And then the consumer would have to check a box for Wells Fargo, Bank of America, Mutual of Omaha, Loan Depot, and then click consent so that the consumer knows exactly who they're consenting to receive calls from. It's a very, very big change. Companies like Lending Tree will be fine, but many of these smaller outfits that frankly kind of run weird, I'll just say weird websites that people go to that are a little bit more exotic, and you know they're going to be in big trouble because they can no longer do this. It also means, though, that the volume of outbound calls is going to be going down, which from a market share perspective might impact some of you. I'm not sure. It also means that smaller companies are going to have a much tougher time getting leads because the big boys are going to occupy, the websites. The websites want to be able to sell that lead, and they want to have that consumer basically recognize the brand that's on their website, right? So if you're Bob's Mortgage Shop of Cincinnati, you're probably not going to compete very well with Bank of America or Mutual of Omaha. So if I'm running a website, why would I put Bob's Mortgage Company on there when I could have other companies that are going to get clicked on who will then pay me for that lead? It's all about money, right? So big changes. That's all I'm going to say about this. Like, it's a big deal for some folks, but you guys don't buy leads, really. It doesn't sound like you're working with companies that are buying leads. So it doesn't sound like it's going to impact you too big. Let me
ask one question on that. Does that also cover emails? Because many of our members do get leads to do broadcast email. Does that fit in here in any way, shape, or form?
Not directly on the one-to-one. Email, as you all know, tightly regulated. You still do have CAN spam, and you still do have state-specific anti-fraud rules that you need to comply with. Can't have fake headers, et cetera, with your emails. But to the extent that you are doing, capturing consent via email, that process is still permitted. However, that process now has to comply with the new one-to-one requirements. So let's take an example. Let's say you're Wells Fargo, right? And you're doing a first-party lead generation effort using email, and you send out an email to 100,000 people. The email today could say, click here to consent to receive information from Wells Fargo Bank N.A., its affiliates and subsidiaries regarding products that you might be interested in. Totally fine. After the one-to-one rule becomes effective, it could no longer do that. Instead, it would say, click here to receive information from Wells Fargo Financial LLC if you are interested in a credit card. Click here to receive information from Wells Fargo Mortgage if you are interested in a mortgage. Click here to receive information from Wells Fargo Student Loan if you're interested in a student loan. In other words, the one-to-one consent applies both in the first-party setting, where you can no longer just obtain blanket consent across an entire brand. You have to get the individual entity-level consent, even if you're Wells Fargo. Now, I'm not sure the emails that you folks are sending, if those are designed to generate consent for yourselves to call, or for a client to call, or for somebody else that might buy the lead in the ecosystem to call. But ultimately, whoever is providing the good or service, whoever that customer is agreeing to buy something from, ultimately has to be specifically and individually named and consented to on the form. And that is true via email, just like it's true in a web environment. So for instance, if you're using your emails to drive the site, to bring consumers through a link to a landing page where they're going to fill out the form on the landing page has to conform to the new one-to-one requirements, if that makes sense.
Yes, thank you.
No worries at all. So that's basically the high-level review of the TCPA. It's not that hard to kind of spit out, and the high-level review of the new change around FCC one-to-one ruling. Happy to answer questions. Now, you also have SIPA here, kind of a different animal. I'm happy to talk about that. We've already covered ATDS, voice, SMS, and chat. Actually, I will say, chat over the phone obviously is covered by the TCPA. Chat over websites is not covered by the TCPA. Although, remember, anytime now you are using AI, right, either to power how an outbound attempt is being made, to power a chat, to power any kind of communication, the FCC is suggesting that you have to have a disclosure, right? So consent for AI has to be obtained on the front end, and then a disclosure has to be made as part of the AI outreach, because we're kind of AI phobic right now. And people, the regulators at least, are going to require these disclosures. So that's something to keep in mind. The California Invasion of Privacy Act is one other thing we should talk about very quickly. Those of you who are capturing consents over the web, and those of you who are recording phone calls, need to know about this anti-wiretapping statute that's here in California. The statute carries a $5,000 per violation penalty. Class actions are also permitted. So from a certain perspective, this is even scarier than TCPA. And those of you that don't have business operations in California, to the extent that you are calling California consumers, or to the extent that California consumers might access your website, you still need to be aware of this, because you can still be sued, even though you don't even do business in California. It's crazy, but that is how California courts operate these days. The rule is essentially this: if you are using a third party of any kind to do any form of web analytics, session replay, recording, your journayas, your trusted forms, anything where the consumer's experience on a website is being looked at, that could potentially be wiretapping, because there's a third party, not just the consumer and the website operator, but somebody else that's in there with apps doing analysis and capturing in real time what that consumer is doing. That in California is treated as eavesdropping and wiretapping. Similarly, if you have a chat bot, let's say you have a chat bot on your website, and that chat bot is powered by a third party, IBM Watson, very common, right? If that third party has access to those chats in real time, and they all do, there has to be a disclosure to the consumer that that is happening, even if they're willfully using the obviously third-party widget. Nonetheless, there has to be a formal consent that the consumer agrees to before that conversation can take place. Otherwise, they'll be treated as wiretapping and eavesdropping. Again, $5,000 per conversation is your risk. So really important for those of you who are capturing communications or web sessions or analytics on websites. I'm not sure how many of you folks that applies to, but that's a really big deal.
Hey, Eric, we got another good question in the chat here concerning consent and how many, is it only good for one particular channel that is discussed or identified at the time of granting that consent, or is it good for all the channels that I may use to interact with you?
So it's going to depend on if it's a marketing call or a non-marketing call. A non-marketing call, the good news is that nice, broad, presumed express consent we talked about covers all your different channels. Express written consent, it is channel specific. However, the good news is that you can capture all the channels in a single disclosure, right? We may contact you using text message, outbound voice, outbound pre-recorded voice, outbound artificial voice, outbound AI, right? Stick it all in the disclosure. I know it can get wordy, and you're fine. Okay, so that is easy enough to capture. It does raise the other interesting question, though, of revocation, something I haven't brought up yet. A consumer can always ask to stop calls. It commonly comes up, and in your setting in the call centers, I'm sure you see this all the time, where a consumer is receiving and has opted into multi-channel communication, but they say, stop, let's say on a text. Do you have to stop communicating with them over the phone as well, using voice? Or do you have to stop email, right? What is the rule around the scope of revocation? Generally, what I tell people is from a channel perspective, the new ruling from the FCC requires that for marketing purposes, any stop request received on any channel requires and mandates you stop communication on all channels. In the informational setting, if you receive a stop, let's say via text message, there's still, I think, a pretty good avenue and argument that you can say, continue to contact that consumer over the phone via voice channel. But the FCC is getting kind of a lot stricter on that. And when you talk about multi-purposes, a set-aside channel, you've got even kind of another three-dimensional issue. They don't want to receive calls for one account. Can they receive calls for another account? Or for those of you that are working, let's say, with multiple companies that retain you, if a customer asks you to stop calling on behalf of one company, can you still call them on behalf of another company that you're doing work for? And all of these are really interesting issues that are very, very context specific. So this is where you're going to want to make sure you're definitely getting some legal advice to help you out. But all of these issues rear their ugly heads all the time.
Catherine, did that answer your question, or do you have any follow-up?
Yeah, the question about explicit.
Yes.
So my question was, if I am on a call with a consumer and I say, hey, listen, may we text you about your appointment? What if I then want to text him about a treatment protocol? I didn't ask him about an explicit type of text, or I said an explicit type of text, but then I'm going to text him for something else.
Yeah, so you've really limited yourself there. If that's the script that you're using, you can't exceed the scope of the consent that the consumer has given you.
Great. Thank you.
Yep.
I just want to point out that we have about 10 minutes left, and I saw that Adam put a question in the chat, so to make sure that gets answered. And for anyone else, don't worry about putting it in the chat. Just feel free to jump in with questions for these last few minutes.
Yeah, Adam, you want to ask your question there, that topic you put in the chat?
Yeah, it seems like most of the calls I get are from some call center in the Philippines or somewhere like that, but they're calling potentially on behalf of a US-based. Do the same laws apply to calls originating from?
Yes, the short answer is yes. So what happens in these instances, just so you folks, if you want to look under the curtain if you don't already know this, again, this lead generation industry is out there, right, trying to warm up leads and qualify people. So let's just take the example of the insurance vertical, which is so common, right? There are literally companies who are brokers, not insurance brokers, data brokers. And this is what they do. They'll go and they'll buy age data. That is, theoretically opt-in data. It might have been from like 5 years ago that somebody filled out a form on some website, and they'll pay that provider, $10 and get 10,000 pieces of data. They'll then take that 10,000 pieces of data, they'll give it to a call center in the Philippines or in Pakistan, and they'll just say, call these people and try to get them on the phone, right? maybe 2 people out of that 10,000 will pick up the phone and agree to be interested in insurance, right? Yet 10,000 people just receive phone calls, so that 2 people might be interested in insurance. And then the lead broker will take that call that Pakistan has and transfer it to an Allstate representative in Houston who has no idea, by the way, what just happened. You know, that 10,000 calls were made, or really it's like 50,000 calls were made because they all get 5 calls each to get that one warm transfer that gets sent over to this guy, because he just thinks he's buying somebody that's interested in hearing about insurance, right? That's all he knows. And so we've got this really disgusting, frankly, ecosystem where the lead buyer, the guy in Houston, isn't really at fault, right? He's just trying to buy a lead, but he's the guy that gets sued, along with, of course, the Allstate mothership, when this call that was made in the Philippines, which is probably illegal, was made. Now, I say probably because the law has been that this, I gave the example of buying opt-in leads from 5 years ago. Now, technically speaking, express written consent does not expire. So you may have actually filled out a form, Adam, 15 years ago, right? Forgotten all about it. And this stupid marketing partner hyperlink that I told you about in the fine print had 10,000 names on it. And your data is just getting circulated and resold hundreds of times a day, potentially. Can you imagine this, being in a business where literally you can always just keep reselling the product over and over and over again? And it does diminish in value somewhat over time, but it never goes to zero. And you can just keep selling the same can of soup, right? Hundreds of times, albeit for less money over time. And that is what's called that's what's caused the robocall epidemic, right? It's not that the Allstate guy is a scumbag, right? It's not even necessarily that the Pakistan people were scumbags. The Pakistan people are calling what they were told was consented data from the broker, who was told that it was consented data from the warehouse of data manufacturer or aggregator, who was told by the actual individual websites that these were legitimate leads, right? And so if you can imagine, you get like 6, 7, 10 layers from where the lead was actually generated to the point where the guy actually answers the phone and tries to sell Allstate. There's so many opportunities for fraud, for lying, and obviously for that consumer to be mistreated, that it still is just a really abusive environment, which is why we created Reach, and which is why we're coming down on these guys.
We had another question in the chat about if a company was seeking some specific consulting assistance, who should they contact? So I know, Eric, we can get your firm's contact information added to this, and I know there's other contact center consultants in our group besides myself, so I'm not going to say call me, but you can certainly David knows who everyone is, but yeah, the great question, because the first step is when you need to investigate, potentially do something, is to reach out and get some additional resources to help you out with it.
I've got a couple of things that are coming to my mind, and I think I know the answer, Eric, but I get an awful lot of unsolicited requests through LinkedIn. Can you shed any light on LinkedIn? Because I know everybody on this call is involved in LinkedIn. Did I sign something when I logged in that said any Tom, Dick, or Harry can reach out to me for any reason?
Well, while we're talking about LinkedIn, let's everyone take out our now and connect with Eric Troutman. I actually through this list and added a bunch. Add a bunch of you. If you connect with me, you're going to get just tons of free content around this. I pump out stuff every day. The LinkedIn terms of service are interesting. Blasted, not cold called, but messaging app all the time. And in the beginning, I used to complain, and they just no, it's not a violation of the terms of use. They're allowed to do that. So yeah, when we sign up for LinkedIn and use their blessed service, we are signing up to receive at least in-app notifications. And there's a very big difference between an in-app notification and an extra app notification. You get push notifications to your screen, and you need to be able to change that setting. And you did probably consent to it out of the gate, but push extra notifications of any kind are communications to a cell phone that do require consent. However, communications via, say, the LinkedIn messaging function use tokens as opposed to phone numbers for delivery, and therefore it's not a TCPA violation, even if you didn't consent to the message.
Thank you for clearing that up.
Hey,
Yeah.
Jill, would you roll to the last slide, please?
Yes, that was just gonna bring that up, Kirby. So here are some resources that Kirby and Eric put together. If you
Yeah,
wanna share
let me just speak to this real quick. So I first came in contact with Eric and his firm several months ago, attended one of their seminars, and it was just extremely informative, along with a couple other companies involved in putting that on. And I immediately went to his TCPAworld.com website, and they're posting stuff out there every day. It's not only rulings from the regulators, but it's actions and rulings handed down by the judges, as well as stuff that's just coming out in the news about someone, a new class action lawsuit being announced. So, I mean, it's just a plethora of information. He talked about Reach, the organization that he created. And yeah, I would encourage you, if you want to be able to track what's going on, what's changing, what's happening, some excellent resources there.
Really good to have you, to be useful for y'all.
Eric, extremely useful. I mean, one of the first questions was, we're going to have to transcribe this because you're moving at Mach 5. And I think there's a whole lot of people that need to learn a whole lot of stuff from this. So I've got some follow-up work to do with you and Kirby, but we can't thank you enough for taking an hour, a non-billable hour out of your day to spend with this group, because it was extremely informative.
Thank you.
That was amazing. Thank you.
That was awesome. Thank you.
Thanks, Eric.
Thanks so much, everybody, for coming today.
Any other questions, Kirby? Anything else?
No, unless, I mean, if anybody else has got anything they would like to ask or talk about.
Yeah, I have a question for you before we stop. Yeah, before we stop the recording. What in the world made you think this, to think of this topic and then to go get this asset, which was awesome? But how'd you come to this conclusion?
Well, it came to mind for me because, as Eric talked about, there's just huge liability out there. And I was working at a client site about 4 or 5 years ago on a project, and they were predominantly an outbound operation, and just huge amount of problems were occurring while I was there doing something else. And this is when the real push was coming by the government, really putting the burden on the wireless carriers to start policing. And they'd always done it to some degree with the traditional carriers, but it really got serious with the wireless carriers. And then that's when you really started seeing all these phone calls getting tagged with possible spam and or just blocking numbers. And the government was like, hey, you know who the bad actors are. You see all these volumes going across your network. We're putting the pressure on you to start doing something about it, or we're going to levy penalties upon you. And so it just made things very, very problematic. And then all of a sudden everybody was scrambling like, okay, how do I get my numbers? So in other words, you outpulse a number, or perhaps your toll-free number, when that to show that caller ID when it rings in on somebody's phone. And you definitely want to have it branded. That's the best way to protect yourselves, and also in hopes of getting an answer. But tons of that was getting blocked, and it was a huge problem. And there were very few resources available anywhere to figure out that mess, that conundrum of, well, God, I'm not one of the bad actors here. I'm legitimate. People are responding. They're filling out web forms on my site and giving me their phone number. And the carriers are blocking my calls. And so there were a couple of companies out there that would say, okay, well, we have relationships with the carriers, and they trust us, and we can kind of act as a clearinghouse to validate that you're legitimate and don't block your numbers. And so anyway, it's always kept me very interested ever since then. And it's just, I wanted, even though I knew the majority of this group was inbound oriented, because of the implications, I felt it would be worthwhile to cover the topic and hope that people could pick up some valuable information.